Why aren't you saying anything?
I thought you were going to say it.
Oh, okay, I'll say it. Sorry, everybody, that's a bit of a false start. Welcome to the first episode of the Lex Rex Institute Podcast. I'm your host, David Truschel. Wait, no, he's David Truschel. I'm Alexander Haberbush, and I'm president of the Lex Rex Institute. I'm also an attorney, although I am not acting in that capacity today.
I'm David Truschel. I'm apparently the only one who knows how to read a script, and I am the lead writer for the Lex Rex Institute.
Well, I usually go unscripted.
Anyway, this is our first episode, you can probably tell. Before we begin, please note that nothing in this podcast constitutes legal advice, and the opinions expressed in this podcast are those of the individuals expressing them, not necessarily the opinions of the Lex Rex Institute.
So, for those of you who aren't familiar with the Lex Rex Institute, we are a nonprofit constitutional advocacy group. Our philosophy can probably be best summed up by our name, Lex Rex, which is Latin for the law is king, because we believe that in America, we are and ought to be governed solely by the law, the Constitution, not by the whims of any person, especially those in charge.
Our goal is to promote public knowledge and awareness of the Constitution and to enable the American public to defend the liberties it guarantees. So this being the first episode of the podcast, the format may not stay exactly the same, but for now, it's going to be the two of us, most weeks at least. You may hear some guests, you may hear other members from the organization, but we're going to be having discussions about developments in U.S. law, whether at the Supreme Court or elsewhere.
And if there's anything you want to hear, if you want changes to the format, something you think would be a good suggestion, go ahead and send that to us. We really do take those comments to heart. We'll do whatever you say.
Yeah, absolutely anything. Whatever your heart desires, we will find a way to do it. That is a guarantee.
Not actually a guarantee.
Don't listen to me. Ignore this. Just, redacted. Everything. So this week, among other things, we're going to be talking about some of the recent developments in the Supreme Court, some of the major things brewing over there.
Brewing. It's mostly a dark blend over there at the Supreme Court. I have no idea what that means.
You don't drink coffee. Do you have any idea what that means at all?
No, sadly, I drink tea like our filthy English cousins.
Yeah, the oppressors. King
Yes.
George over here. Actually, he was German. He probably didn't drink a lot of tea.
Probably not. Probably drank Jägermeister.
That may be a little xenophobic, but
I'm sure that was
on.
popular back in the 1770s, right?
Sure, let's pretend. Anyway, we do expect this episode to be released very early in May, probably not actually on May Day.
Yes, we've actually got a special program for you today. Normally we're going to review the Supreme Court docket, but today, in honor of one of our important holidays, well, David, you introduce it.
Yeah, so May Day, also known as International Workers' Day, is the favorite holiday.
Workers of the world unite. You have nothing to lose but your chains.
Yeah, exactly. So we thought it would be fun to talk a little bit about communism and how that fits into American law.
Is it legal to be a commie? Well, you'll find out a little bit later on this episode.
Yeah, spoiler, it's not the best to be a communist in American law, as it turns out.
Well, it certainly doesn't help you.
No. So, yeah, why don't
Turns out
we...
you have more to lose than your chains.
Yeah, that's true, and we can actually start talking about that. So we wanted to talk specifically about one federal law and one part of the California Education Code. Why don't we talk about California first? This is from the California Education Code. This is a quote. We're not making this up. It's real. You can believe us.
This is still current law, by the way. This is not just old law. This is currently on the books.
On the books, has not been repealed. No teacher giving instruction in any school or on any property belonging to any agencies included in the public school system shall advocate or teach communism with the intent to indoctrinate or to inculcate in the mind of any pupil a preference for communism.
You heard that, teachers?
Yeah. So
Can't do
basically, yeah.
You can't try to inculcate a preference for communism. You'll be fired if you do that.
Yep, no, that's completely true. You're breaking the law if you try to make any of your students into a communist, and I hope you take that to heart.
He's not joking.
This is genuinely extant California law.
And actually, you understated the law by a bit. It says inculcate a preference for communism, so you don't even have to try to make them communists. Just teaching them that communists are sympathetic and they're right about some things, and well, that runs afoul of Education Code Section 51530.
Yep. It goes on to say that it's not trying to prevent anyone from teaching facts about communism, but
Just trying to make people like it. It's like the University of Woolloomooloo. You can teach any of the socialist philosophers as long as you make it clear that they were wrong.
Now, one of the things that I noticed when we were reviewing this that I thought was very interesting is that the statute does define what it means by communism. So it says, for the purposes of this section, communism is a political theory that the presently existing form of government of the United States or of this state should be changed by force, violence, or other unconstitutional means to a totalitarian dictatorship which is based on the principles of communism as expounded by Marx, Lenin, and Stalin. Now,
that part I find confusing because, sure, Lenin and Stalin both advocated for totalitarian dictatorship, but Karl Marx was very ambiguous about that.
Yeah, and that's certainly true. And the fact that it says and Stalin rather than or Stalin isn't helpful here because it would need to line up specifically with Marxist-Leninist Stalinism, which is a pretty
can Bernie
specific...
Sanders be a teacher in California? That's the question.
Probably depends on who you ask. But
we're not going to voice our opinion on that today.
No, the thing that I noticed, though, that I thought was of particular interest is that you can definitely be a Trotskyist and be a teacher in California. He and Stalin definitely did not align. Very different forms of communism. So apparently that's okay. But, just no Stalinism.
So before we move on, if any of you have kids that are currently in the public school system, if you feel that they're being subjected to communist indoctrination, well, you've actually got a cause of action for that. And while the Lex Rex Institute has not previously litigated under Education Code Section 51530, we're always open to it. So give us a call. We may be able to take care of your child's communist teacher, have them, physically removed, so to speak.
Okay, wow.
From the school,
Yeah, all right. Anyway.
You can be a teacher, but you're still not given full protection under federal employment law. So let's turn to that next.
Yeah, this is a fun one too. So this is federal code.
This is the United States Code.
Yes, this next one.
Applies in every state of the union.
Federal law, and this is the broader context here is that it's law defining unlawful practices of employers. But then there's this little subsection
So
F.
So just to give you a little bit of context for this law, federal law has various things you can't do as an employer. And many of those things are also in the Bill of Rights. So there are things like you can't discriminate against somebody on the basis of race. You can't discriminate against their political views, for instance. You can't fire somebody because, they wouldn't go on a date with their boss. Stuff like that. And this law that we're going to read right now creates an exception to that generality. So, David, go ahead.
Yes, it does. So the subheader for this section is members of Communist Party or Communist Action or Communist Front organizations. And it says, as used in this subchapter, the phrase unlawful employment practice shall not be deemed to include any action or measure taken by an employer, labor organization, Joint Labor Management Committee, or employment agency with respect to an individual who is a member of the Communist Party of the United States or of any other organization required to register as a Communist Action or Communist Front organization by final order of the Subversive Activities Control Board pursuant to the Subversive Activities Control Act of 1950.
See, 1950 makes sense for a law like this. The California one, believe it or not, that was from 1976. You know who signed that into law in California?
You told me, but tell me again.
Jerry Brown.
Yep.
That's the governor that we just had before the current one. We had him, years ago, back in the 70s, and he signed this anti-communist provision into law. But here, I noticed one of the key differences in this federal law is that you have to be a member of some kind of communist organization. It's not just about the ideology.
Yep. That's true. And so, it's about being like a card-carrying member. But it's also, there's a lot of leeway that's afforded by this section.
I was thinking about having my employees, requiring them to register as communists so that I can do whatever I want to them. That's not true. That's a joke. Please, that's a joke.
Yeah, well, and I'm not sure how many
could
would be
do
willing
that,
to do that anyway. But yeah, and this law remains on the books. So I guess
So it's anything that refers to an unlawful employment practice in this chapter of the code, which is the chapter referring to unlawful employment practices, doesn't apply if you're a member of a communist organization.
Yep. So I guess for International Workers' Day, I guess the best advice we could give is make sure you are not a member of a communist party.
No, I can stand by that. We're a non-political organization, but I think that I can genuinely say, from a legal standpoint, most circumstances, it's not advisable to be a commie.
Yeah, that's a better way to couch it. Under most circumstances, we can't really advise that you join a communist party. Purely for employment law purposes. Yeah. Purely for employment law perspective, of course. We're not making any judgments about politics.
No, of course not.
Yeah. Anyway,
that's your business if you want to privately go around espousing communism.
Oh yeah, no. We have no input there. So
well, I feel like we got to move on to our next section now.
Yes, happy May Day.
May Day special.
Happy May Day, but let's move on. Okay.
Workers of the world, consider before uniting. You have more to lose than your chains.
Exactly, like your job. All right, another thing, it's been all over the news lately. We've been following some of the updates on our Facebook platform and otherwise about all of this. But Ginni Thomas, who is the wife of Justice Clarence Thomas, continues to make headlines as various congressional committees under Democratic leadership have made noise about imposing by law an ethics standard on the Supreme Court, calling for very specific guidelines for when justices have to recuse themselves, and even
not a good idea.
In certain quarters, even threatening the impeachment of Justice Thomas. And I guess first of all, we should talk about what is it that Ginni Thomas did that has raised all of this. This is something you actually addressed on one of our videos previously.
That's right. That was one of the Ask an Attorney videos, I think, from 3 or 4 weeks ago.
Yeah.
I think it's called Did Clarence Thomas Act Improperly? And it's on our YouTube channel, Lex Rex Institute on YouTube. You can find that if you're interested.
Yeah, I would recommend that you check that one out, if only to see the actual firsthand evidence of what happened with Ginni Thomas, which is interesting and amusing, in my opinion.
Yeah, well, let me read one of the text messages. So all of this revolves principally around text messages, right? So it's text messages that she had sent to, was it the chief of staff, right?
Yeah. Oh gosh, I'm blanking on his name. Well,
Mark
at
Meadows,
any rate,
wasn't it?
Yes, I think that's right.
Chief of Staff Mark Meadows, and variety of things. Basically, like keep going with the investigation. You keep up the
for anyone who doesn't know, I guess we should clarify. This was the chief of staff for President Trump under the last administration, and she sent him a series of text messages around, I think, exclusively before January 6th, but possibly continuing afterward. At any rate,
and it's not traditionally. It was pretty far outside the scope of something that could plausibly be considered grounds for a judge to recuse himself. Get into that more in the other video, but the text message that I wanted to read is this one. So this is a quote. First text message is a quotation. I assume it's either a paraphrase or a direct quotation from like a Breitbart or some kind of news outlet like that. Yeah. And she says, Biden crime family and ballot fraud co-conspirators, and then she lists the conspirators, are being arrested and detained for ballot fraud right now and over coming days, and will be living in barges off Gitmo to face military tribunals for sedition. Then she comments, I hope this is true.
Yeah.
Clarence Thomas has subsequently made the claim that he and his wife do not talk about the Supreme Court's calendar or the items that are on docket. And given this text message, I'm inclined to believe that's true.
Yeah, that was my takeaway as well. That she thought it was plausible that at least like a half a dozen high-profile political figures were going to be, for some reason, loaded on.
Listen, elected officials, bureaucrats, social media censorship mongers, fake stream media reporters, etc., are all being arrested and held off Gitmo.
Yeah, on barges too, for some reason, which that's one of the strangest elements to me. I don't know why you would pick a barge. As far as I'm aware, the Navy doesn't maintain any barges.
Look, I mean, people that really believe in a lot of this deep state stuff, that that there are secret tribunals taking our rights and whatnot, This is more egregious than some of the more outlandish claims that you hear in that. Like,
Oh,
if
yeah.
you know really anything about due process, I feel mean, almost mean saying it, because she's not a lawyer and there's no reason she should be expected to, I guess, know this stuff. But it feels like if you've been following the news much at all, you would know that this probably isn't true. And even if you thought it was, I don't know why you'd hope that it's true. This is very, very dangerous.
So that's one thing I want to bring up here is, even assuming, and I think from the text we can probably conclude that Ginni Thomas felt that the last presidential election wasn't quite kosher, let's say.
A lot of people felt that way.
Right, and felt that Donald Trump should have
the
been the
2,000
winner.
sworn affidavits they gave some people cause to suspect that something had run afoul.
At any rate, I think we can assume her motivation here is for, the preservation of America as we know it. That's what all of the,
upholding
the
our
talking points are about. Yeah, whatever you believe about the events of the last presidential election, we won't comment here.
Both sides thought or think that they were preserving our republic.
Yeah, and it seems like if that's your motivation, then one of the last things you should hope is true is like the mass incarceration of civilians who are then going to be transported to Cuba for military tribunals.
Military tribunals for sedition.
Yeah, that seems like arguably a bigger deal than the outcome of the election.
I mean, this is really, because remember that the protests that were in Hong Kong in 2019 about the extradition law that Beijing had passed, saying that people who were accused of certain crimes in Hong Kong would not be tried under Hong Kong law, but would be extradited to Beijing and tried under Communist Party mandate.
Yeah.
And that was basically viewed as the total upheaval of the entire way of life in Hong Kong. Well,
yeah. And we should clarify that.
This is tantamount to that.
Yeah, we should clarify that previously, due to the terms of a treaty with the UK, Hong Kong was governed under British law.
Yeah, actually, their judges, I think their judges are appointed by the Queen of England.
I think that's true, unless that has changed in the aftermath of the recent years. But at any rate, basically the takeaway with the Ginni Thomas text is that there doesn't seem to be a reason to believe that anyone would rely on them for substantive guidance in doing pretty much anything. And the involvement with her husband,
but imagine if
Thomas,
he had. Imagine if Mark Meadows had said, "Oh, that's a really good idea. I'm going to round up fake stream media reporters and put them on barges off of Gitmo." Then should Clarence Thomas recuse himself?
Well, I guess that's a separate question. But anyway, that's not what happened.
I actually argue that he shouldn't, because the case had nothing to do with that.
Yeah, no, that's all very true as well. But in any case, what actually happened was that the Supreme Court was called on to rule about the disclosure of certain documents from the Trump administration pertaining to January 6th of last year. Justice Thomas was the only dissent. The other 8 justices voted to allow those documents to be disclosed.
That was actually the Texas v. Pennsylvania case that you're thinking of.
Okay, I was only ever hazy about the specifics. But in any case, that's the basis, though, for all of this. Is the claim is that because his wife had been texting with someone in the Trump administration, that he now has a conflict of interest in this case. And
because his wife has an interest in people being sent to barges off of Guantanamo Bay, then Clarence Thomas must, I'm trying to follow the logic here, must have an interest in finding in favor of the state of Texas when it claims that whether or not other states had followed their election laws impacts their ability to pick the president.
Yeah.
I'm just not seeing the connection here.
No. And so I guess part of the problem here is that this is really not how judicial conflict of interest works. I think the thread here, and this may be generous, is that he wouldn't want those text messages disclosed because they reflect on his wife, who reflects on him.
They wouldn't even have been disclosed in that case.
And so I suppose there's some sense of him wanting to avoid embarrassment, but that's really the extent of the connection as far as I can tell. And that's, we've discussed this off air before. That's really not what conflict of interest is meant to do. Or
conflicts of interest mean
that
you sit in a position where the outcome of the case will have a material impact upon you that either harms you or benefits you.
Right. And frankly, I'm not sure how that's supposed to be the case here.
Unless, I mean, I suppose the opinion of the court could have been that we'll start sending fake streaming media reporters to barges off of Gitmo. And if that, well, even then, that's actually not a material benefit. That's just something that's just the desired outcome. So,
yeah,
I mean, to Ginni Thomas, not to me.
Yeah, so I guess, good clarification. I think we can say that pretty much universally we are not in favor of these Gitmo barges.
You know, that feels safe, David. I'm not in favor of putting anybody in a Gitmo barge.
Yeah.
And that's not just my opinion. The Lex Rex Institute will stand by that.
That feels like a pretty safe one.
We got to keep moving them.
Yeah, so I guess the takeaway here, if there is one, is that a judge having an opinion about something is not the same as having an interest in the case. Most judges probably have opinions. At any rate, let's move on.
And we do cover this more in depth in a video about this issue specifically. But speaking of the Supreme Court, did you see that? So a few months ago, David wrote the script to a video that we made about a case called Mcgirt v Oklahoma. Mm-hmm. And did you notice on the Supreme Court's calendar, they're actually hearing sort of a follow-up to that case, Oklahoma v Castro Huerta?
I did, yes. So this was one of our earlier YouTube videos that I may be so bold, I think is one of our better ones. So I urge you to go check that out.
That script you wrote is fantastic.
Well, thank you. It's called No Reason Pessimism Should Prevail. That's a quote from the court's opinion in that case. So if you're interested, I think it's a fascinating case. And I guess before we talk about Castro Huerta, we should probably give an overview of Mcgirt and what Mcgirt did.
Yeah. Do you want me to do that, David? Or?
Sure. Yeah, go ahead.
Okay. So to keep it really simple, because the issues are fairly complicated, but Mcgirt v Oklahoma basically looked at an Indian man living on an Indian reservation in Oklahoma who had committed a crime that is listed in an act of Congress. I think the act of Congress is called do you remember? I think it was the Major Crimes Act, if I'm not mistaken.
I think this one is Major Crimes. A similar law, General Crimes Act, is key in Castro Huerta, but yes. I believe it was the Major Crimes Act.
That's correct. But anyway, long story short, the way jurisdiction works on Indian reservations about who can prosecute a crime and in what court is very, very complicated. But essentially, what the case hinged on was whether or not a treaty that had been made with the Cherokee Nation prior to the incorporation of Oklahoma as a state still continued to be in effect. Because if it did, then Oklahoma did not have jurisdiction to prosecute this case in Oklahoma State Court, and it had to be heard in federal court. And basically, the opinion of, again, this is in the video too, but basically the opinion of the court was that the law should remain the law. And the fact that nobody has cited this treaty for a long time and nobody's tried to raise claims under it, and the fact that Oklahoma has ignored it for a long time doesn't mean that it doesn't exist. Therefore, the finding is in favor of Mcgirt. That was the litigant in that case.
Yeah, and so in practical terms, one of the things that resulted here is that a huge proportion of the land in the borders of Oklahoma has now sort of had its status as Indian reservation re-recognized, if you will, where Oklahoma had established state courts and, basically ignored reservation status for a very long time. I think I remember reading that it was up to 40% of the land in Oklahoma.
It's a substantial proportion.
Yeah, is now going to be considered to be Indian reservation. And we should add, by the way, we know there's different terminology that's used for indigenous peoples of North America. There actually is, like in law, the term Indian is a technical term. It's a term of art.
That's correct.
So, don't be offended if we talk about Indians in Indian country. Those are actually the legal terms.
Be offended if you get offended, because we're just citing the law.
Yeah.
But we won't. We don't really. Use whatever words you want. We don't.
Yeah, just to clarify, in case that was bothering anybody. But, so that was Mcgirt, and that was decided last year or late in 2020?
Calendar.
Okay. Castro Huerta, the argument in this case took place, I think, a couple days ago. That was, I think, Wednesday, April 27th.
Did they already hear oral argument on this?
I believe they did, yes.
I missed that.
But at any rate, Oklahoma has sort of had some
They don't
objections.
like the ruling.
Yeah.
They have a lot of courts, and they spend a lot of money on those courts, and there's a bunch of them, and they want something to do. And technically, so the way that Indian reservations work, there's concurrent jurisdiction with the state. They exist occupying, in many instances, the same spaces of land. You've seen on a map, there's a shape that's Oklahoma. That shape is still Oklahoma, but portions of it are shared jurisdiction with Indian reservations. So the way that Indian law versus state law devolves upon different people varies based on the person, the circumstances, and the location. So what's very, very clear, and what Mcgirt made abundantly clear, is that if a member of an Indian tribe commits a crime against another member of an Indian tribe while on an Indian reservation, state doesn't have any jurisdiction over that. Now, we also know that if somebody who is not an Indian, somebody who is just an Oklahoman, commits a crime against another person who is not an Indian, just an Oklahoman, and that takes place on the Indian reservation, that is within the state's jurisdiction, that can be heard in state court. So what's now being heard in the Oklahoma v. Castro Huerta case is, I'm going to flip this, I know, but it's either where the defendant is an Indian and the victim is not, or where the victim is an Indian and the defendant is not.
Yeah, I'm 95% sure that the defendant is not an Indian and the victim is in this case. Not 100%, but
the reason I'm not sure which way it goes is that the law is the same whichever way, because both of those are actually entertained in a law we mentioned earlier, the General Crimes Act, which actually does specifically by name reference crimes that are committed by an Indian against non-Indian or against whichever is the flip of what I just said.
Yeah, sure.
And so the question is, or at least the argument that Oklahoma is trying to make, is that even though the federal government's made its position very plain on this, because states have general jurisdiction over their sovereign territory, they should still be able to prosecute this person in state court. In my opinion, that's not correct. The reason that's not correct is that treaties with the Indian tribes exist under the authority of Congress. That's the same authority by which a state can enter into the Union in the first place. So if a treaty with an Indian tribe predates a state's adoption into the Union, then that Indian treaty continues to be in effect unless it is either explicitly or implicitly abrogated by an act of Congress, which has never happened. So I don't think it even gets to the point where it becomes a preemption issue. I think it always just remains an issue of state versus Indian sovereignty.
Yeah, I didn't read through all of I think it was the oral argument, again, because I'm pretty sure that already happened, and I think that's what I was
you generally
reading.
hear an oral argument.
Well, I was reading a transcript if it was indeed oral argument and not something else that I was reading. I'm pretty sure it was that because I think there was back and forth. But at any rate, you seem to be broadly echoing what Justice Neil Gorsuch seemed to be getting at, which was that as far as he's concerned, the
tend to agree
issue
with
really,
that guy.
Yeah, generally. We're mostly pretty big fans of his.
We'd love your autograph, Neil, if you're listening.
Yeah, I think we both have his book. So if you want to, send us a signed copy of that.
I bought copies of his book for pretty much everybody in Lex Rex.
Yeah, he seemed to be pursuing the same line of reasoning that this is really an issue that has to do, first of all, with the treaty rather than anything downstream from there. But one of the things I think was interesting, both in Mcgirt and in this case, is that Oklahoma, or at any rate Oklahoma's attorneys, have wanted to steer the argument toward basically a balancing test.
We don't like those.
We tend not to like those, true. So basically, balancing test, in so many words, inviting the court to consider the practical, tangible benefits to different parties and how to best balance them.
Yeah, it's about interests. So
yeah.
the actual thing the Constitution protects, or the law protects, is one interest, whether it's free speech or whatever it may be. And then whatever the government wants to do to you is the other interest. And then we just kind of compare the two of them, and then we see which one there's more of, and we go with that.
Yeah, that's a pretty blunt way of putting it, but that's not really inaccurate. Over and over again, and I haven't read everything on this case. I didn't read everything on Mcgirt, but I read enough, I think, to get a general sense that, in addition to other arguments, this isn't the only argument they made, but Oklahoma was very interested in pointing out the potential drawbacks of reorganizing the jurisdiction in this way. And, they've continued. So at the time,
it must be illegal because it would be very hard for us to do.
Yeah. So
of
in
the
the
argument.
McGirt case, it was very much, for decades we've been doing these things. We have all these courts, we have police precincts in all these places. We're enforcing laws in this particular way. Why upset?
You're telling us we
cart?
wasted all this money?
Yeah. And in this case, in the case of Castro Huerta, they're talking about allegedly thousands of crimes that are going unprosecuted because no one's in a position to prosecute them if Oklahoma can't do it.
I mean, there's still
Obviously,
federal crimes.
Yeah. And, they've basically said, well, but the federal government isn't in a position to prosecute them.
But the FBI is no good at what it does, so
Right.
what are we supposed to do? I mean, that's sort of
and-
the same issue that some of these border states are looking at with the Biden administration's refusal to enforce some of the immigration law, where they've entered into a compact for the enforcement of borders.
Yeah, I believe in Texas v. Biden, basically one of the issues has well, we won't get too in-depth into this, but
Be a good one for next week, though.
Possibly, yeah. Among other things, one of the questions that was raised in court was, they were basically saying we need the Biden administration to, to take this particular
We're talking
interpretation
about the border issue now?
Yeah.
Okay.
Just for a second, I just wanted to make one quick point. Basically saying Texas, among other states, is trying to enjoin the Biden administration to enforce immigration policy in a particular way that they say is consistent with the underlying law. And at one point, a question came up in court, has any administration ever enforced this law consistent with how you understand it? And they were basically like, no, they haven't. So it's been an interesting few months as far as that sort of issue goes.
And that gets into issues of Chevron deference and interpretation of administrative law. There's some real bad Supreme Court precedent saying that executive agencies are the best interpreters of their own enabling statutes, which is just madness to me.
Yeah, that's a pretty heavy issue and maybe one that we should get into on a different podcast. I will say just very briefly, we do have a written article recently that delves into Chevron doctrine a bit that I think has the title something like Why You're Likely Wrong About the Constitution, something like that. You can find that on our website. It's got some,
if anybody's
details about
better
that.
at doing headlines for articles, hit us up.
Yeah, if you've got better ideas for what we can call things, that's another suggestion we'll gladly take from you.
I come from a world where you label something like First Amended Opposition to Defendants. So, not my skill set.
No, but at any rate, if you're interested in that and learning a little bit more about Chevron doctrine and administrative agencies, you can look at our website, lexrex.org, and you can find that article there. Yeah, so anyway, these Oklahoma cases have been fascinating. I think it's something to watch for sure.
They are a really good demonstration of, I think, really two competing ideas of law that are sort of struggling against each other in modern America. And those are, is the law what it says on its face? Or is the law whatever is most conducive to the kind of society we want to live in?
Yeah.
Because really the only sort of argument that Oklahoma can make in a case like this is that ruling against them would result in consequences that are undesirable. And, frankly, it's to the court's credit that they actually had the courage to stand up and say, we don't care about that.
Yep.
Actually, Gorsuch said it much more eloquently than that. The full quotation's in our video, but
yeah,
that's really the two views of law that are at play here.
Yeah, and I think it's worth noting too that often this idea of what's going to be beneficial is highly subject to interpretation. For one thing,
judges are the least capable of any person in our government to answer that. They're not elected. They serve life terms. Most of them are very well educated, older.
Yeah, they have a very specific point of view generally, and that's in interpreting the law, that's not necessarily a drawback. In terms of making holistic decisions for American society, it very much is, and that's why Congress is set up the way it is, and it's meant to draw on a whole wide array of interests and backgrounds.
Supreme Court is about the least representative group of 9 people in this country. If you picked any 9 people you could think of to see who represents the entire United States the worst, it'd be hard to find a group of 9 that accomplishes that better than the people who are on the Supreme Court.
Yeah.
I mean, they all went to one of 2 schools.
Well, no. Barrett went to a different one.
That's right. You're right. One of 2 schools.
Barrett went to a different one. Yeah, there's that. Almost all
For
of
a while,
them
I
for
think
the
there were
past,
5 justices that were born within 4 blocks of each other in Brooklyn.
yeah, pretty much every justice for like the last 50 years went to Harvard or Yale and was from New York. And you're right, like basically one neighborhood, more or less.
So
New
if
York.
you are serious about representative government, you really don't want the Supreme Court to be the ones that are doing it for you.
No. What they can do, though, what they're trained to do, and this is why we want legal professionals to be as educated as we can get them to be, is understand the rules of how the law is interpreted and then apply them.
The better a judge you are, the more responsible of a judge you are, the less things like background and personal experience should matter.
Right, because what you're being asked to do is very limited in scope. You're being asked to say, what is the law and how does it apply to the facts that are being presented?
Here's a sentence. Here's where the commas are.
Yeah.
Here's how this subordinate clause affects the...
In many instances,
here's how these nested prepositions work.
Yeah, it is that mechanical sometimes. I forget what we were talking about a few weeks ago, but we were talking about something, there's exactly that, where you asked me like, oh, how would you read this? And I gave you one answer, and then I thought about it, and I was like, no, it needs another comma.
That was another case recently.
Yeah, I forget which one that is.
But it was great because it was right after the late Justice Scalia had passed away, and he was probably one of the main proponents of almost rigidly, we want black letter tests for this stuff. We read things exactly as written. We don't read them even the way we colloquially read them, frankly. And then right after this, we get both sides of the court. They're just doing standard statutory interpretation. They're both doing textual criticism of the statute. I think it was a list, and the last item in the list was unclear whether it was supposed to be read as an adjective that modified the... I'm getting way too nitty-gritty.
Yeah, we're getting into
Let's
the
move on to
weeds
our
here.
next subject.
So this is going to be the last one for this section, and then we'll move into our last segment after this. And I think this is a case that neither of us know a huge amount about, but we thought it was
Speaking of
important
balancing tests, though.
Yeah, we thought it was important to bring this one up, though. It's Kennedy v. and I'm assuming it's pronounced Bremerton. Could be Bremerton. I don't know. And I'm not even sure what state this place is
Bremerton.
in. But
that's
anyway,
right, it shouldn't be.
Yeah, we'll call it Bremerton School District. And so basically, this is a First Amendment case. Kennedy, I think his name is Joseph Kennedy. Interestingly
I didn't know
enough.
he was still alive.
Anyway, he was
I don't think it's
a
the
football
same guy.
coach. I don't think it is.
It's not the famous bootlegger and ambassador?
No, I don't think so. Pretty sure different guy. He's a football coach at a public high school in this school district. And the facts of the case, as I understand them, and I'm hazy on this. I think you're a little hazy on this too. But this is as best we understand it. He had a habit after each game ended of walking out to the 50-yard line and praying, taking a knee, praying. And at first, as I understand it, he did this completely alone. And then later, some of the players would join him doing this.
Sounds like it was unprompted. They just kind of joined him of their own initiative.
Yeah, at the very least, that's his account of it. Because the opposition account hinges on the idea that there was some kind of indirect coercion involved in this. We can talk about that in a bit.
I think I don't know that they're saying coercion. They're saying just endorsement.
Well, there's two things going on there, and let's shelve that for a second. We'll get into that. One of the key facts here, at least that they've been talking about, I'm skeptical that it really matters that much in actual matter of law, is the fact that the crowds were still present. So basically, the school was viewing this as a public act that he was doing out of
a
concern.
display, more than a act of, I guess, devotion.
Yeah, and again, this is one of the things I'm hazy about. I think there was some kind of disciplinary warning, but apparently pretty soon after this came to their attention, he was fired. And as near I can tell, basically the reason they cited for firing him was that they didn't want to expose the school district to charges of having endorsed religion by permitting him as an employee to perform a religious act in this public manner.
They were thinking of cases like Wallace v. Jaffrey, 1985, where a moment of silence, it was supposed to be a non-religious moment of silence, was held unconstitutional. If schools are seen as endorsing a particular religion or even religion generally, that's something that can be viewed as running afoul of the Establishment Clause.
Yeah, and So one of the big issues here is that the technically still extant precedent about Establishment Clause, and the Establishment Clause is part of the First Amendment that has to do with establishment of religion, or in other words, the government endorsing or establishing a particular religion as the official religion or a favored religion. The precedent that still governs.
Oh no, it's the ghoul from the late night horror movie. I know what he's going to say next.
That's a Scalia quote, or a paraphrase anyway. It's called the Lemon Test, named after another case.
Here to haunt our Establishment Clause jurisprudence yet again. Very famously in the Lamb's Chapel v. Center Morich's Union Free School District case, a 1993 case, Scalia was so fed up with the fact that the court would repeatedly slay and then re-invoke this Lemon Test that he compared it to a ghoul in a late night horror movie. It's a very funny section. It's worth looking up.
Yeah. So basically, no one wants it around. Everyone wants to get rid of it. Everyone recognizes basically.
The key to its success is that it's so easy to kill.
Yeah, that it's bad, bad law. Almost everyone will tell you that it's bad law.
And we talked about balancing tests earlier. Lemon Test is sort of the archetypal balancing test.
Yeah. But no one has thus far at least articulated a better way that has been accepted or definitively killed it off for good.
The last part of what you said made the former part correct. There have been a lot of other standards that have been articulated, but they have not been accepted. Notably, I think Rehnquist's standard from Wallace v. Jaffrey, I think that's certainly the most constitutionally supported, which is that the Establishment Clause prevents the federal government from creating an established church.
Yeah, and I would certainly argue that that's the clearest understanding of the First Amendment, that, the term establishment of religion had a very specific meaning.
David's degree is in religion, and I think specifically history of the church.
Sort of. Close enough, anyway. So,
all that to say, you should trust him on this stuff.
Establishment of religion is a very clear reference to the established church in the United Kingdom. The Church of England, the Church of Scotland, Church of Wales. Those situations have changed a bit in British law, but essentially
still do have
they do have established religions. The Church of Wales has been disestablished, but the Church of England, the Church of Scotland, and I believe the Church of Northern Ireland are still established churches.
The Queen is still technically the head of the Church of England. That is an established church. And that is, when Thomas Jefferson refers in his letter to the Danbury Baptists of a wall of separation between church and state, that's what he's talking about. That somebody who is an officer of the state would not, by virtue of being an officer of the state, also hold some kind of religious title.
Yeah. That may seem obvious, but it historically has not been obvious. All kinds of societies have, to this day, actually, I think
across the globe, the celestial emperor in China.
Yeah, but continuing to the modern day, Andorra, which is one of those European microstates that's only for rich people and probably right in the middle of France, basically.
I think it's between France and Spain. It's in the Pyrenees.
Yeah, that's right. By constitution of Andorra, it has two what are called princes. So they're heads of state, technically. One is the president of France. It used to be the king of France until they got rid of him. But the other is a Roman Catholic bishop, whose bishopric is in Spain. You're right. So it is between France and Spain. And they're just kind of we've had it this way for a long time. We don't see a reason to upset the apple cart. Why not, right?
And David's picked a very obscure example here, but it's really very pervasive. I go to church with a guy who lived in Germany for a few years, and it was not that long ago. It would have been 1980s, I think. Mm-hmm. And when he was getting paid by his employer, his paycheck asked, as part of his tax withholding, what church he wanted his taxes to support. Whether it was Protestant or Roman Catholic.
Yep, Germany's not the only one. There are at least a few other European countries where the state diverts tax money to specific churches. Yeah. And that's just sort of part of the fabric of their society. And it doesn't seem that unusual to them for the most part.
When a lot of folks hear separation of church and state, I think that they hear separation of religion and state. And that's, in many senses, I think that's showing the blessings of having lived in a country that has the First Amendment and has had the First Amendment for 250 years. Because if we did not live in such a society, I think that what establishment of religion refers to would be very, very clear. And we would see the clear and obvious benefits of having institutional separation between the two.
Yeah. Anyway, to bring it back to Kennedy, there's been a lot of confusion about that and whether or not, the original interpretation is right. I think we can say that the history of legal interpretation of the First Amendment has drifted pretty far away from that original scaffolding.
That's why I refer back to the Rehnquist opinion in Wallace v. Jaffrey. It's sort of the central piece expressing that, because he goes through the whole, he says, I don't agree with anything that the majority opinion has just said. Here's how Establishment Clause jurisprudence actually ought to work.
Yeah, but so in this particular case, I think I queued up the audio for this.
Let me just, before we do that, I'd like to just go through the prongs of the Lemon test, so we keep referring to this Lemon test. Let's say what it is. So it's 3 prongs. First is the statute must have a secular legislative purpose. What does that mean? Nobody knows. No, it's basically you have to show that there is some goal that's being advanced by this legislation that is secular in function. I don't know how you determine what's secular and what isn't, because many of the moral precepts or values that are advanced by religions are the same as what a moral person who is non-religious would advance. That's the first prong. Second prong is the principal or primary effect of the statute must neither advance nor inhibit religion. That's similarly ambiguous. And then the third prong is the statute must not result in, and this is a direct quote from the case, an excessive government entanglement with religion. And there's 3 factors for that. The character and purpose of the institution benefited the nature of the aid the state provides and the resulting relationship between government and religious authority. But as you can see, excessive government entanglement is not a workable test. That depends entirely on the opinion of the person asking.
And, what constitutes entanglement? How do we determine what's entangled? And in this case, it seems to be the opinion of the school district that an employee visibly praying where people can see him is excessive entanglement.
Yeah, well, you see, he's the coach of the football team, so he's like in charge of the football game. So people might think this is an official part of the football game if he goes out and prays on the field afterward.
Yeah, part of the controversy in the argument seems to hinge on whether the school district's actions have to be measured just by what they explicitly said they were doing when they fired the coach, which, again, I don't have all the facts, but I think it seems to be that they said they didn't want to be seen as endorsing religion. And secondly, so whether they need to be judged on that or whether you can introduce reasons that they didn't bring up. And then the second question seems to be whether they really were only saying it was about endorsement of religion. Well, I'll play a clip of the audio where they go
moral
to
argument?
that. Yes. So let me make sure you can hear this.
Justice Gorsuch.
Mr. Clement, one of the difficulties of this case is getting one's hands around the district's rationale. And as I understood it, was based on kind of our Lemon endorsement test. And you're arguing, as I hear you, that was a mistaken test. And it is a mistaken way to think about what the Establishment Clause requires. You had a colloquy about coercion as an alternative, and I'd just like your thoughts on that subject generally.
I appreciate the question. I don't think, people are trying to dispute this record. I think it is very clear on what motivated the district. And it was endorsement again.
Not coercion.
Not coercion. If you look at their first letter after the October 16th game, Joint Appendix page 90 to 95, there are 8 references to endorsement or endorsing, 0 references to either coercion or player safety.
The question that he was addressing there was what resulted in the firing of the coach. His contention, and it seemed mostly like it was true, was that the school district had said they were concerned about being perceived to be endorsing religion. So that's why he kept saying endorsement.
It seems to me like you run into the exact same problem if you fire the guy, though. If that's really true, then aren't you also endorsing irreligion? You fire him.
Yeah, no, that's a perfectly valid question. And it seems like, whether for that reason or for other reasons, I didn't read enough to be confident about this. The school district apparently realized after the fact that they really didn't want to be hanging their case on this. And so at the very least, their counsel started redirecting and saying, well, it wasn't really about the endorsement, or it wasn't only about the endorsement. What it was really about was coercion of the students or the players who would possibly feel that they had to participate.
To make that argument.
Yeah.
They have to make that argument if they want to stand any chance.
Right. And so then
there just aren't facts to support that.
Yeah, that's one of the avenues it seemed to be taking, was they were trying to make a case that there was this kind of indirect or soft coercion that was going on, basically because if the players see him praying, they will think, I guess, that he wants them to join him in this prayer.
Prayer time now.
Yeah, that if they don't, their playing time may be affected, or, he won't think well of them. And,
See, there has to be facts to support that, though. You can't just say the mere fact that an authority figure is doing something means that other people now feel compelled to do similarly.
Yeah, and I will say,
as far as I've seen, there just aren't facts to support that in this case.
Yeah, I will say I haven't seen everything to do with this case, so that maybe they do have some facts in that lend credence to that. Maybe they've adduced some evidence in that direction. I haven't seen it if they have, but
if somebody does say, you have to pray with me in a sectarian prayer, or I will somehow make life at this school worse for you, whether you'll play less on the field or your grades will be worse, you'll be kicked off the team, whatever. That would present clear Establishment Clause problems.
yeah.
It just doesn't seem that's what's going on here.
I guess we do have to include the caveat. We haven't seen everything, but it seems like it's a real tough row to hoe to make that argument.
Well, keep in mind, the Supreme Court hears cases on appeal, and appellate cases generally are not going to revisit factual findings from lower courts unless there's plain error.
Yep. That case is still ongoing, hasn't been decided yet. We may be back next week to talk about what they did decide. Or
I would be very surprised if this went in favor of the school district.
I'm inclined to agree, but, we'll see. Cliffhanger, tune back in next week.
If I'm wrong, I have to eat a gavel.
Uh-huh. We are not going to specify right now what that gavel will be made of. It could be chocolate, but...
See, that's a lawyer trick.
Anyway, that'll wrap up that case, and we're going to transition into our last segment of the podcast. We don't have a name for this yet.
Don't say it.
I'm gonna be pitching things to you, and my first thought, and I want the pitch to be on air so that the listeners can respond as well. It's the law sauna, where we're going to bask in legal hot takes. Now,
yeah.
I know you hate that name.
Two fat men. I don't know that's a mental image anybody wants.
Fair enough. Although I do think that's kind of.
Or I'll call myself fat. You're fine.
No, I'm fat. But classically, at least in my experience, fat men are exactly who go in saunas.
Yeah, that's my experience as well. Not that I've had a lot of experience in saunas, but from.
No, but the gym that I used to go to had a sauna as part of the locker room facilities. I hate saunas personally. I don't like the heat. Not a big fan.
I don't like sweating.
But yeah, no, I agree with that. But it was always old men, past their physical prime, let's say. That was always who was in it. So anyway, but
if you like the name law sauna, I suppose that's an option.
Yeah, hashtag law
Otherwise,
sauna.
we're probably going to be renaming this.
Hashtag law sauna. And if not, yeah, we'll try a new name out next week. But basically what this is I've collated some examples of people's legal analysis online. You haven't seen any of these, so we're going to be getting your live reaction.
He means me.
Yeah, you as in Alexander Haberbush have not seen any of these. So without further ado, let me pop up the first one.
All right. What, these are videos or?
No, most of these are actually. I think all of these are going to be just screenshots, but we'll read them.
So you need to share it.
Yeah.
Of the screen sharing.
All right. So as you can see already, this is something to do with a Krispy Kreme donut, and
yeah. Let's see. Krispy Kreme has made a sweet announcement. Now people, let's stop moving it like that. Okay, now people who have been vaccinated against the coronavirus can get a free original glazed donut. All you need to do is show up to a store with documentation proving you got your dose or doses.
And it goes on. So this is someone responding, and she says, "Such cheap #bribery might be a breach of #Nuremberg codes. Neither donut makers nor #journalists have right to convince people to take #experimental treatments."
Now, are the donuts the experimental treatment or the vaccine?
I think we can assume it's both. No, but for any of you unfamiliar,
donuts aren't that healthy for you either.
That's a good point. And actually, unrelated to this, I did see someone objecting to it on those grounds. I think that was a doctor saying you shouldn't offer people donuts for the vaccine because that's just as unhealthy as anything else.
Was this person think the vaccine was healthy or unhealthy?
Yes. So that doctor was advocating the vaccine, but pushing back on the donuts. This person, I think we can assume.
They like this. This person thinks donuts are a fairly substantial inducement to get vaccinated,
yes.
apparently.
And so much so that they could be war crimes.
Yes.
And then, just to piggyback on that, someone else says, excellent, and it violates HIPAA regulations.
Okay, so are we showing this to me to ask me if it violates the Nuremberg Code or HIPAA?
Yeah, why not weigh on both of those things, I guess?
No, knee-jerk is no.
Yeah, no, I think that's right. I'm pretty sure.
Not sure what section of the Nuremberg Codes they're referring to. I'm trying to rack my brain here. I don't even know what that could be a reference to. And as far as HIPAA is concerned, this doesn't require disclosure of anything. You're voluntarily disclosing the medical record to Krispy Kreme.
Yeah, I've seen HIPAA crop up a lot about people concerned about various vaccination requirements. In many instances, they seem to believe that anyone talking about anyone's medical treatment in any capacity is a violation of HIPAA. Is that true?
Yeah.
I guess you tell me. Is that accurate?
No, so HIPAA actually has to do with healthcare providers disclosing or not disclosing medical records. It has to do with basic due diligence they have to practice for privacy of people's medical records. There are other medical privacy regulations that generally prevent non-medical persons from disclosing medical records as well, but HIPAA is more specific than that.
Yeah, all that to say.
The Nuremberg Code's about war crimes. It's not really about
donuts or vaccines.
Oh, no, not particularly.
Yeah. All right. So anyway, that's the first one.
All right. Well, that was fun. Just so everybody's aware, Lex Rex takes no stance on the efficacy of vaccination of any kind or whether or not somebody ought to get it. If people do have sincerely held religious objections, medical objections to vaccination, or even if you just want to assert bodily autonomy as your objection to vaccination, we are prepared to defend those claims for anybody that wants to bring them.
That is very true, but we would recommend not relying on the Nuremberg Code if you have to argue.
I had a client that really was like begging me to insert these Nuremberg claims into the demand letter that we write. And then he had a section of the California Code showing where the Nuremberg Codes have been incorporated into the California Code. But my thought was, why don't we just cite something that's actually law in California? Because you can see it's incorporated right here. Just cite this. Mm-hmm. And it had to do with using experimental treatments.
Yeah.
On people.
Yeah.
Okay, so that might have been what this person was thinking of. Maybe I think the combination of vaccine and donut is experimental.
That could be, yeah. We have not tested the effects of the vaccine on someone who has just ingested or is just about to ingest a glazed donut.
Right. Just so everybody's aware, the Nuremberg arguments about experimental treatments have to do with test subjects of experiments.
Yeah.
It doesn't just mean that the medical procedure is one that has not been properly tested, which is absolutely true for these vaccines. They're only subject to the emergency use authorization. The mere fact that they have not been fully approved does not mean that every person that they're distributed to is a test subject.
Right.
I think that's a stretch. I'm sympathetic to that, going that direction, but I don't think the argument works.
Yeah. Now, this next one, this is actually going to be in two parts. And I bring this one up specifically because knowing you may take a very particular stance on this.
Oh, we may have to edit out my response.
That I think other people will not. Well, no, this is all leading into a grammar joke. So let me show you. This is the headline, first of all.
Definitely have to edit out my response then. Suspect told the police, I'm sorry, you guys can't see this.
Yeah.
The suspect told the police, give me a lawyer dog. Court says he wasn't asking for a lawyer.
Yeah. So,
give me a lawyer, comma, dog.
Yeah, and now let me bring up the second part.
There's no comma in the headline, by the way.
Right. That's why I was curious how you would respond to this.
So this has got to be in a Miranda context, right?
Yes, it is, and you'll see. So
he's invoking his right to an attorney, and they're saying he didn't ask for a lawyer; he asked for a lawyer dog.
Yes. So
even if that were true, he could just be mistaken about the ability of a dog to sit for the bar and have a law license.
Yeah. So I'll read this next part. This is from the actual text of the article.
I would, some people could think that dogs could be lawyers. I don't know.
When a friend says, "I'll hit you up later, dog," he is stating that he will call again sometime. He is not calling the person a, quote, later dog. But that's not how the courts in Louisiana see it. And when a suspect in an interrogation
it's Louisiana, that'd be why.
Told detectives, we'll need to delve into that in a second, why Louisiana specifically.
I don't just dislike Louisiana.
Yeah, well, there's a specific reason. When a suspect in an interrogation told detectives to, quote, just give me a lawyer, dog, the Louisiana Supreme Court ruled the suspect was in fact asking for a lawyer dog and not invoking his constitutional right to counsel. It's not clear how many lawyer
really
dogs.
mad because even if he had been asking for a lawyer dog, there's no reason to think that's not invoking his right to counsel.
Yeah, it's not clear how many lawyer
He's not
dogs.
legally required to know who's allowed to be a lawyer and who's not in order to invoke that right.
It's not clear how many lawyer dogs there are in Louisiana and whether any would have been available to represent the human suspect in this case, other than to give the standard admonition in such circumstances to simply stop talking. So
I only want my lawyer dog to answer questions for me.
yeah.
He was probably saying, "I want a lawyer dog."
Yeah,
like calling the police officer dog.
I think that's almost completely, indisputable. But I guess so. So we are on the same page on that one. I'm glad. But I think we should talk about why.
But again, I would say even if he was asking for a lawyer dog, I still think it's a valid invocation of his right to counsel.
Yeah, no, that's a fair point too. They could have told him there are no lawyer dogs, but we can get you a lawyer.
That's not a thing.
But at any rate,
Louisiana does not recognize canines as suited for bar membership.
yeah,
Okay, so when I mentioned the Miranda context a second ago, most of you guys are probably familiar with that already. You've seen that in every procedural TV show about police officers. They say, you have a right to remain silent. Anything you say can and will be used against you. You have a right to an attorney, so on and so forth. Well, the way that the courts have interpreted Miranda rights to attach is that once somebody is suspected of a crime and the police want to interrogate that person, so ask that person targeted questions with the purpose of eliciting incriminating information. If they want to do that, they have to read the Miranda rights. And then at that point, if somebody invokes their right to an attorney, the police have to stop asking questions. And if they didn't stop asking questions, if for whatever reason they kept asking questions and still managed to elicit incriminating information, that would be excluded from evidence in court. The court could not use that because the police had questioned the person illegally. So really, by saying that this person asked for a lawyer dog, when clearly this person is at least trying to invoke their rights in a Miranda context, they're almost certainly being wrongfully convicted of a crime, which is a very serious thing. You're not going to say anything, David?
I thought you were doing a monologue here.
I guess it is the hot take section, but...
Yeah, no. Yeah, so this will be true for everything in this section. There may be very serious problems with what's going on. We don't mean to make light of that. We're just focused on the absurdity of the interpretation here. Don't interpret this as us saying, this doesn't matter. It matters a lot. It's just also ridiculous.
It's an absurd legal conclusion.
Yeah. But anyway, speaking of Louisiana, we should clarify your remarks about Louisiana in that context. It's not just that we're saying Louisiana's a bad place or a bad state.
So as you probably remember from your history classes, George Washington, Thomas Jefferson bought Louisiana as part of the Louisiana Purchase from Napoleon in I'm going to get the year wrong, but early 18 teens for $15 million. That's a good price. But because it had previously been a part of France, the legal system in Louisiana is completely different from the rest of the United States. Every other state in the Union has a common law system, whereas Louisiana has a statutory system.
Yeah, which we'll probably have to save what that means in depth for a later podcast.
Practically speaking, it just means all their names for everything are different.
Yep.
All things just works a little bit differently there. Who knows? Maybe dogs can sit on the bar there.
Yeah, I'd like to see that, I think, especially if he can speak French.
I saw a 1930s movie where they dressed up a bunch of dogs in little outfits and then had them on strings and stuff. And they did a trial where a basset hound was the judge and all the dogs were all the litigants.
Yeah,
that might have been in Louisiana. I don't know.
That's probably what the judge thought he was talking about, and he was like, "Well, we don't have that movie." Yeah. All right, anyway.
That's not real. You don't get a lawyer.
This is going to be our last one for this week. This is a good one.
Okay, so this looks like a tweet again.
It is.
And it says, "Dude, the elected representatives passed a law and governor signed it. They are all elected by the people. That is the definition of a representative republic and constitutional. Courts are not elected, and if they try to mess with past laws, that is unconstitutional.
So do you agree?
Okay, I don't know any way to address this other than just to break it down. Okay. All right, the elected representatives passed a law and the governor signed it. Yeah, that is how laws are passed. They're elected by the people. That's true. That is the definition of a representative republic. Well, I mean, it's a state. Sure, okay.
Well, you forgot the second part of that. That is the definition of a representative republic and constitutional. So automatically...
Therefore, it's inherently constitutional, I think is the argument that he's making here.
Yes. Automatically, any law that's passed and signed...
any law that went through a legislature and was signed is constitutional, so courts can't mess with that. Yeah, that checks out. That's right.
Yeah. I think I recall there being a pretty important Supreme Court case about this way back when.
This actually predates the Supreme Court. We've mentioned on a couple of the Ask an Attorney videos. The idea of judicial review goes back to Dr. Bonham's case, which I think is from like 15 teens. Again, I can't give the exact year, but it's during the reign of Elizabeth I that we have, and that's just the first documented mention of judicial review. We had a long oral tradition of English common law way before that. But even without a written constitution in Great Britain, judges still stood in judgment over the acts of the legislature when those acts went against the traditionally accepted rights of the British subjects. So, it goes way back. It predates the Constitution. The Constitution is predicated upon the idea of judicial review. That's part of the basic function of what the judiciary does. And just kind of it's upsetting that Lex Rex hasn't reached these people yet. So
yeah, well, and I guess that's a good way for us to close. You can help us help people like this.
This boy needs help.
Yes.
You remember those sad commercials that had the kids in Africa, and they would say, $1 a day can feed this kid, and you always watch it, and you just feel horribly because all these kids that are suffering, and I actually I watched it, and it's like, I feel horrible about that. And then it's like, no, they're manipulating me into feeling horrible, and then I kind of resent them for doing it. But that's what we're going to do with this guy. Because Lex Rex doesn't have the reach that we would like to, this poor boy doesn't understand what a constitutional republic is. And he goes around saying things that get him made fun of on the internet. And that's just not... That's not a good life to live. So $1 a day from one of our subscribers can keep this kid off of Twitter and can make sure that he knows what the Constitution says and understands what a constitutional republic is.
Yeah. So
$1 a day.
All that to say, it doesn't need to be $1 a day. It could be anything, but we would really, really appreciate it if you would consider donating to us. You can find information about that on our website, lexrex.org.
I don't think you can do ongoing.
Not yet. We're working on that.
You got to do one-time donation.
Yeah, but if you wanted to say like $1 a day for the rest of your life, and you estimate that at 30 years, that would be great. We'd love that. But
that'd be a good amount.
It can be less than that. You could just give us $1. That would be fine. But
or even just give us a name for what we are currently calling the law sauna.
Yeah. So, I'm sensing some hostility from my co-host as to that name.
No, not at all.
We'll revisit that. But it doesn't need to be financial either. We'd love donations, but we'd also love you to get involved. We have certain programs that we're running. You can find more information about that on our website. We'll talk about it here. And even just sharing our website, any of our posts, this podcast, we'd hugely appreciate it. And we hope that you will. And with that, I guess, thanks for listening to this first episode.
Yeah, thanks for listening. Hopefully we'll do many more like it, or not like it, if you guys didn't like the format.
Yep, exactly. All right. So goodbye, everybody.
All right. Good night.